SJC-10571 Farahani versus the Bristol County Superior Court.
Good morning, Mr. Farahani.
Good morning, Your Honors, and thank you for this opportunity to be heard here. My name is Godrat Farahani, and I'm representing myself with regard to this case. This case is about my inability to proceed in the Superior Court with regard to certain civil cases that I am prosecuting and or defending on my behalf. I have experienced repeated inability to speedily or swiftly achieve what I wanted. I file motions, I file complaints, and they sit on the docket. I request the clerk to present it to the judge, and they advise me it's sitting in the judge's lobby for months. I have two civil cases that was dismissed by the clerk for lack of service, even though under those two civil cases, there were pending motions to enlarge time, motion to stay, motion for additional relief, and those motions were not disposed of. And I can cite to one case, case number 2008-431. The complaint was filed on March 31st. A motion was filed on April 23rd. It was not disposed of. An emergency motion was filed on 0506.
This was to stay service?
The motion to stay was to stay the proceeding because I requested to be absent from the docket for certain medical issues. And it was not ruled on. Then I filed another motion to enlarge time to file notice of appeal, and it was not disposed of. Then on 0709, I filed a motion for, on 0709-2008, the case was dismissed by the clerk for lack of service. I filed a motion to vacate.
If the case has been dismissed for lack of service, you could take an appeal from that dismissal?
I am not quite sure. There is a new standing order in the Superior Court which gives the clerk 90 days to dismiss a case if service has not been returned.
No, I understand that. But if a case has been dismissed, normally what the normal route of appeal, excuse me, is to go to the appellate court to take an appeal.
That is correct. You file a notice to appeal. And I did file a notice to appeal, and I asked for enlargement of time, and that was not even disposed of. So the judgment of dismissal, which is issued by the clerk according to the standing order, gives the party a chance to vacate that order. And I did file a motion to vacate that order, and I'm still waiting for it, and it still hasn't been disposed of.
But those motions don't stay the appellate process. In other words, excuse me, if you come to this court, it is typically for a very extraordinary situation where there's no other way that you can get the action that you want. If your case has been dismissed, you can take an appeal from that.
You're correct, Your Honor. My issue here is not this particular case. I see a pattern, whereas certain judges do not desire to preside over my case. I write to them, I request them, I file emergency motions. I have several cases, as I stated. And I see a pattern. I am not here to undo certain cases that has been dismissed. I am not here to ask you to vacate any judge's order. I am only here requesting this court to bring some a better quality of justice in the Superior Court. I cannot believe why judge after judge would refuse to dispose of my motions, whereas they will immediately dispose a motion to dismiss or a motion for judgment. This case is about access to court, Your Honor. And the complaint before you was really filed as a complaint pursuant to Massachusetts Rules of Procedure 8A. It was not filed as an appeal. It was not an interlocutory appeal. It was basically filed as a complaint to bring to your attention that there is an issue there. There is a pattern of delays, and I cannot proceed with my underlying claims when repeatedly I see my motions or my pleadings are not disposed of, or they just sit.
Mr. Farahani, what is the nature of your underlying complaint? Against whom is it?
These are basically insurance claims and personal injury claims, Your Honor. There was one case that was filed in 2003. I moved the judge to allow me to amend my complaint in order to add any other claim or any other defendant that I desired, and he denied that. So I ended up splitting the complaint to additional complaints. And unfortunately, when I'm pursuing the additional complaints, I keep observing the same situation. Certain judges do not desire to preside over my case. They are assigned to my session, but they will not preside. And I see often the clerk moves my case to a judge that is not assigned to my case. In the Superior Court, Your Honors, judges rotate. Judges are assigned to each session, session A, B, and C, or D. For example, my session is session C, certain judge is presiding over that certain judge will not dispose my cases. They pile up, and then there is 20 motions or 15 motions, and then a judge which is not even assigned to that case presides over it in half an hour and he decides all those motions. And I am saying this is not acceptable. This is not a proper way to provide justice, a quality justice to someone like me. If those justices do not desire to preside over my case, they should recuse themselves. They're not entitled to abstinence. They're not entitled to delay. Your Honor, my due process and my right for equal protection has been repeatedly injured. That's the best word I can use, Your Honor. Commonwealth's opposition says, where is the proof for all this? You only have filed a complaint, you have made certain allegations, you have written to Chief Justice for the Superior Court asking her to order her judges to preside over these cases or over these motions. And the Commonwealth says Mr. Farahani failed to support his allegations before this court. Well, Your Honors, I filed a complaint here. I had no other opportunity. I have filed similar complaints in the Superior Court and they get dismissed. I have not had the opportunity to be able to move this court to grant me the reliefs that I'm looking for. I even filed a similar complaint in the United States District Court. I asked them to enjoin the state justices who refuse to preside over my case or refuse to dispose of them. And that particular court advised me to seek remedies here, to exhaust my remedies. And I'm exhausting my remedies. I have nowhere to go. I cannot go back to the Superior Court and file yet another complaint and asking them to move themselves to preside over my case or to dispose of my motions. You are the only hope, Your Honor. This is the only place I can go. And I am not asking to reverse any order. I am only asking this court to order the Superior Court and its justices to properly and timely and efficiently dispose of my motions and cases. I ask nothing more, Your Honor. Therefore, Your Honor, this case is really about access to court. I did not file extensive brief. I did not want to file legal arguments. I did not want to attach exhibits and dockets. I went to the single justice court for an opportunity, a limited opportunity to prove these allegations are true. She denied me that. As soon as the complaint was filed, it was denied a few days later, and then I had to come to this court, the full court. I'm asking this court to send this complaint, this case, back to the single justice and give me a very limited ability to prove these allegations, that there is a pattern of delays, conscious, intentional delays. There is a pattern of justices who do not want to sit on my case. They are refusing to carry out their judicial obligations, and that is not acceptable to this court. In fact, there is nothing more important to this court than making sure that the justice is carried out properly, that those employees of the judicial system will carry their duties according to the law. Thank you, Your Honor.
Thank you, Mr. Farahani. Ms. Bailey, good morning.
Good morning. May it please the Court, my name is Christine Bailey, and I'm Assistant Attorney General appearing on behalf of the named judicial and clerical defendants. It is the defendant's position that the single justice did not abuse her discretion or err as a matter of law in denying Mr. Farahani relief. He primarily seeks relief under two statutes, 211.3, the General Superintendent's statute, and 249.3, the Mandamus Relief Statute. As this Court is well aware, these are statutes in which relief is granted only in extraordinary circumstances. Mr. Farahani does not carry his burden of demonstrating that the extraordinary circumstances exist here.
Ms. Bailey, let me ask you this. Have you looked at the underlying dockets?
I have, Your Honor.
And are there clients who are represented by Mr. Farahani whose cases have been dismissed? I mean, I'm looking at I'm talking about the dockets about which he's complaining in the Superior Court.
Yes, Your Honor.
I'm concerned here about the public interest here. Do you know what the nature of those complaints is?
I haven't, Your Honor, gone and found the actual complaints. My review of the dockets suggests that, as Mr. Farahani says, that the claims involve insurance companies and perhaps some personal injury claims. But I do not know. I have not reviewed the actual complaints that he has filed in Superior Court.
You've listed the docket numbers, or most of them, maybe all of them, on pages 16 and 17 of your brief.
Yes, Your Honor.
So that's the status as best you can tell from the dockets of each of those cases.
Yes, Your Honor. And actually, in order to facilitate the Court's review, I compiled a record appendix, which I submitted to the Court, that actually includes all the docket sheets for the identified dockets that Mr. Farahani referenced in his papers. That being said, Mr. Farahani primarily complains about one docket, which is 2004-1370. In that particular instance, the Court granted the defendant's summary judgment. And in that particular instance, Mr. Farahani would have had an option of appealing that adverse decision to the appeals court. So it's a good example as to how Mr. Farahani had an available and adequate remedy and does not have to resort to seeking relief under these particular statutes. As to the remaining dockets, Mr. Farahani doesn't really argue with any specificity any particular motions that the Court did not rule on or any particular issues that the Court did not address. So it is hard for the judicial and clerical defendants, as well as this Court, to really assess his claims in that regard.
Can you tell from the dockets whether there are motions that are not ruled on?
Well, I did review the dockets. It seems to me, as a general principle, without saying with absolute certainty that every single one of his motions has been ruled on, that in all of the cases that Mr. Farahani complains of, he has filed motions, and the Court in many instances has adjudicated those motions. as Mr. Farahani acknowledges, in some of those cases, the matters were dismissed because he failed to complete service. Also, in some of those cases, and these are detailed in my brief, Mr. Farahani didn't appear or oppose dispositive pleadings, and the cases were dismissed. Also, in a number of these dockets, Mr. Farahani also appealed or availed himself of the remedy of appealing adverse decisions. So he does, if a close examination of the docket reveals that he is aware of and capable of accessing his appellate rights when he wants to. And unless the court has any further questions, we would rely on the brief.
Have some judges recused themselves from his work?
I can't answer with absolute certainty. I can say that Mr. Farahani has brought some motions to recuse certain judges in his cases. The ones that I did look at suggested that the judges didn't recuse themselves in those particular instances, but I don't have that information available with perfect clarity.
Thank you, Ms. Bailey.
Thank you.